All rise. Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Wendy Berger on my right and Judge Rand Wallace on my left. If you have a cell phone, we would appreciate it if you would silence it, please, so that the parties aren't interrupted. The last case on the docket this morning, Sachs versus Vanderbilt, has settled and has been dismissed, so if you're here for that, you're welcome to stay or you may go home. We have 2 civil cases on the docket this morning. The parties will have 20 minutes per side. Appellant can reserve whatever amount of time he or she chooses. Just let me know and I will set the clock accordingly. You'll be into your rebuttal time when it starts to flash yellow. Since we only have 2 cases this morning, I don't think we'll take a morning break, but after we finish the 2 cases, we'll invite counsel into the lawyer's lounge to join us for coffee if you choose to. So with that, we will call our first case, which is KRISTEN Curry versus Volusia County. You may proceed whenever you're ready.
Good morning. May I reserve 5 minutes, please?
Yes, ma'am.
May it please the court, my name is Stacy Ford. With me at counsel table is co-counsel Kelly Hastings. We have the honor of representing John J.J. Curry's surviving wife, KRISTEN Curry, his young son, Owen Curry, and his estate. J.J. Curry was a 30-year-old husband, father, and Volusia County firefighter when he was killed in November 2007 after being on the firefighting force for less than a year and after having just joined a special force firefighting team called the Firewalkers. He was killed in a drill for the Firewalkers. Only 7 months prior, the leader of the Firewalkers team had specifically warned in a written email to Volusia County's battalion chiefs that that allowing personnel to fell trees, particularly dead trees, who had not been formally trained via the power saws course given by the Division of Forestry, which is the S212 class, was particularly dangerous, and that such personnel had not taken the opportunity to take that class recently.
You're talking about the email that's April the 6th, 2007, is that correct?
Yes, Your Honor.
Okay, and in that email, it doesn't mention specifically the power saw training course, is that correct?
Actually, no, Your Honor, it does. The email from Jamie Burnside, the second paragraph, refers to having recently hosted a wildfire power saws course. That's the name of the DOF, the Division of Forestry's S212 course, the wildfire power saws course. Refers to having hosted it, meaning DOF had given it there. And the last paragraph of Jamie Burnside's email actually also refers to quote-unquote formal training that I would submit was referenced back to that particular class that he had mentioned in paragraph 2. And then importantly, the battalion chief's response refers to the DOF class, which Mr. Burnside had already identified. And in the very last line of the battalion chief's email right back, he says, I highly recommend taking the power saws class from DOF.
Okay, and what they were conducting when this unfortunate accident occurred was a training exercise, correct?
It was a drill. It was not a training It was not one of the training courses that are listed in the curriculum for the firewalkers. Attached to each of the depositions in the record, there is what looks like a grid of names of firewalkers and the training courses to be taken by the firewalkers. Those are training courses that are set out by the Division of Forestry, including this wildfire power saws course. That's the firewalkers training. What occurred on this day was a drill.
Okay, how would you differentiate a drill between a training exercise?
Well, Your Honor, I would submit that the difference is that a drill is designed to be a refresher course for those who are already trained and on the team. It is not designed to be an initial training.
But didn't they get them in there and have them watch a video and tell them what they're supposed to do, and then after that, then they went out to the field and were learning how to fell the trees? I think drill versus, basically they were being trained in.
I think it's important for the court to understand that this drill involved watching a 20 to 30-minute video and going out having brief instruction and then cutting down a tree. This entire drill took less than 2 hours before JJ was killed. In comparison, the power saws class that the emails specifically identified as what should be taken before personnel should cut down trees is a week-long class involving 50% of that time in the classroom, 50% in hands-on. So there is a big difference between a 2-hour drill and a week-long Division of Forestry class.
In the video, did they reference warnings to people that were conducting the exercise of felling trees, such as, designated escape routes, don't turn your back on the falling tree, don't turn your back on the cutting of the tree, things of that nature? Were those warnings contained within that 20 to 30-minute excerpt from the video?
There was some testimony as what was in that video, but the testimony was not consistent. For example, one of the most important things to note is that the cutting down of dead trees by the Division of Forestry, we have testimony that says the Division of Forestry's class says you should never cut down dead trees. Those should always be bulldozed because they have hidden dangers in that you don't know where it's rotten, where the weight of it might fall, things like that. If I remember correctly, 2 of the people who testified said that they did not recall that the 20 to 30-minute video watch that day referenced that, including Mr. Woods, who was the person in charge of this particular training. He testified he was unaware that was a DOF requirement that you not cut down dead trees.
And the video was not made a part of the record on appeal, is that correct?
The video is not in the record on appeal.
Is it your contention that the email from Captain Burnside is sufficient to satisfy the requirement that there be an explicit warning about a known danger?
It is, Your Honor. The email refers to this being very dangerous activity twice, both in the email from Mr. Burnside and in the response from Mr. Inglet. They both say it's very dangerous.
How do you, though, deal with the argument that, depending on, I understand that you construe what was going on out there as a drill, and others might construe it as a training exercise, and it might actually be a little bit of both if there's a difference. But how do you deal with the argument that they recognized that it was a dangerous situation, and that's precisely why they were out there trying to practice? So obviously it didn't go very well. I mean, I don't think anybody can dispute that the county's performance in this exercise was below what anybody should expect. But there's a big difference between negligence or even gross negligence and an intentional tort, which is the hurdle that you find yourself having to jump over. How do you deal with the idea that that wasn't the way they tried to deal with the known danger, which was to conduct this training exercise, which admittedly didn't go very well?
Your Honor, I would say that if this email had only said that we need to be training these people, that would be an entirely different case. But this email refers specifically to the wildfire power saws course and formal training, and the battalion chief specifically says that he highly recommends that everyone take the power saws class by DOF.
Wasn't the battalion chief out there when all this was going on?
Mike Inglet, I do not believe we have any testimony in the record that Mike Inglet was out there.
I'm talking about Burnside.
James Burnside, there is testimony that he was there. The testimony was that he was not in the immediate area, but that he was on the grounds, if I recall correctly.
We do know that Lieutenant Woods was out there, and Lieutenant Woods had completed the Department of Forestry training, correct?
Lieutenant Woods had completed the Department of Forestry training about 10 years prior, and what I find really significant about Lieutenant Woods' testimony is that Lieutenant Woods, as I already said, testified that he was unaware that you should not ever cut down dead trees. He did testify that he preferred to cut down live trees rather than dead trees, but he didn't testify that he was aware that DOF says you shouldn't. Meanwhile, we have the testimony from Mr. Greathouse, and Mr. Greathouse specifically testified that he was asked the question, so for this particular training exercise, what would have been the appropriate training model or package that should have or could have been used to train these folks to do it appropriately? He said there isn't one, because they wouldn't have cut down dead trees. He was asked, what do you mean by that? He says, they're dangerous and unpredictable. You have no idea where they're rotted out, where the weight balance is, what's going to break off and come down from above. You use bulldozers and push them over. That's what they teach you in the chainsaw class, referring back to that DOF class. So yes, Mr. Woods had taken the DOF class, but it was over a decade prior. He testified he was unaware of this very specific instruction that the DOF class provided and that Greathouse testified to.
Let me ask you to shift gears for just a minute and deal with one of the constitutional issues. How, if at all, was the issue of the adequacy of the compensation available to a workers' comp claimant brought up or teed up to the trial court? I think we all recognize the Supreme Court has said that workers' comp's an adequate, as long as it provides an adequate remedy, it's a substitute for court action. So the question under the current statute, and I understand that wrongful death limitation on liability now, I guess, is $150,000. Is that right?
That's the cap.
Right.
There's a cap.
So how, if at all, was the adequacy of that compensation and whether that constitutes an adequate alternative to court action brought before the court, or was that issue litigated?
It was litigated, although the opportunity, I don't believe, was very well fleshed out. And the reason being that the constitutionality of the 2003 amendment was raised in the response to the motion for summary judgment. It was raised in a motion to amend the complaint to allege a new count challenging the constitutionality. And then when, during the summary judgment hearing, the lower court effectively said he didn't believe that a motion to amend was necessary, it was further raised in the motion for reconsideration, and I can, on rebuttal, I can provide you the exact page, but it's particularly in the motion for reconsideration, the argument was raised that this statute, the 2003 amendment, was unconstitutional on its face because the alternative was not an adequate alternative.
But there wasn't any, I guess the other question would be, to the extent that, well, that was a facial challenge and not an as-applied challenge.
Both were made. The as-applied was earlier made.
What I have with that is, when I looked at the record, I didn't see anything that from a factual standpoint, really addressed the adequacy of the remedy, because, I mean, there could be cases where $150,000 would be adequate compensation, and there could be other cases where it could be grossly inadequate, and it seems to me that that becomes a factual dispute.
Well, actually, Your Honor, I think the better way to look at the adequacy issue is to look at the statutes involved. If the 2003 amendment had not been passed and we were proceeding under the wrongful death statute, the wrongful death statute, let me just find my notes on it real quick, provides that the spouse and children can receive the full wage loss for the entire life, reduced to present value. Pain and suffering.
Is it a fair comparison to equate to the tort recovery under the wrongful death, or are we really comparing the 2003 workers' comp law to the one that preceded it, the workers' comp law that preceded it, which set the bar for intentional tort and gross negligence lower and provided for greater compensation? I mean, I'm trying to figure out, what do we compare it to?
What I believe Your Honor should compare it to is what the common law was in 1968 for the remedy of intentional tort resulting in death, which would be the wrongful death statute, which allows for not just wage loss, but pain and suffering, loss of parental comfort, and all of those things to the child, versus what the work comp statute provides under the 2003 amendment. So under the 2003 amendment, not only is there a 150 cap, in some cases, they might not ever get to that 150 cap because the statute specifically limits the spouse's recovery. Everybody is limited to wage loss recovery in the first place, but it's not even 100% wage loss recovery. It's, for the spouse, I believe it was 40%. If the child, if there was a minor child, it would be an additional 16%. If there's a child without a spouse, it's 33%. So there have been numerous cases in which the courts have said that the Work Comp Act, when a action is taken away and the Work Comp Act is substituted in, that's okay because the Work Comp Act provides substantial benefits, full wage loss, and we're submitting that, Your Honors, the statute, just looking at the two statutes, the wage loss is not full. The cap of 150 is, you still got to get to that cap even. Some people might even get to that cap.
And just as we're going to hit your 5 minutes, let me ask one other question, and that is, why would we look at what the common law remedy was in 1968? I went back and looked, and it looked like the first workers' comp law was passed in Florida back in the 20s or 30s. Mm-hmm. And so I'm just wondering why you focus on 68 as opposed to looking at something that predated that.
Well, 68 is when the Declaration of Rights was passed, and under the case law regarding access to courts, Kluger v. White says that when the Declaration of Rights was passed in 1968, that the people were assuring to themselves all rights that were in existence in 1968, and that the legislature, under the Kluger v. White analysis, cannot take away any of the rights that the people had in 1968 unless they provide a reasonable alternative. So that's the reason for that point in time, Your Honor.
Okay, you want to hold on to the rest of your time?
Yes, please, thank you.
Thank you so much. Ms. Jones?
Good morning, Judge. Good morning, Judge Berger, Judge Wallace.
Morning.
My name is Nancy Jones, and I represent the County of Volusia in this case. I want to quickly follow up on a couple of the facts that were brought out by you all and clarify what we believe the record shows with regards to those specific facts, because I think they're important. First of all, with regards to the training or the training drill, if you will refer to the record on appeal at page 193, it's the notice of what the drill is going to be, and it calls it the next team drill is scheduled for. So it's our position that there's no distinction between a drill and a training, that the Firewalker team leaders are equally capable of training the Firewalker team members as, say, the Department of Forestry. In other words, it doesn't require the Department of Forestry to come and conduct this training. There's no evidence in the record that shows it's required to be performed by the Department of Forestry, the S212 power saw course.
Hold on. I think I heard you say that the Firewalker team leaders are equally capable of performing these training exercises compared to the DOF folks, is that?
Well, if I misstated that, I didn't mean to imply that the DOF is more qualified, but the DOF class that they're speaking of in this case repeatedly is the S212 power saw course. The leader of the training of the firewalker team the day of this tragic accident was a team leader who had that course and who had been with the fire services for a number of years, had been an initiating member of the firewalker team. So it's our position that nothing precluded him from doing the training. Now, they weren't attempting to certify these firefighters in that DOF course. No, that would require training, official training or formal training by the DOF. But it's our position that the email that was sent by I believe it was Captain Burns said back in April of 2007, simply said the obvious, that felling trees is a dangerous activity and shouldn't be done without training. I submit to you that, as I believe Judge Wallace recognized, it didn't say that formal training had to be the DOF course, and there's nothing that in the record that requires that the training prior to cutting down trees be the DOF course taught by DOF. The training that day consisted of watching the DOF videotape on the power saws course, and it's important to know that the power saws course deals with, and the record shows, how to use power saws. And yes, there is a practical portion of cutting down or felling a tree, according to the testimony in the record.
But did that address, I know we don't have the video in the record on appeal, but to your knowledge or your party's knowledge, did the video address felling dead trees?
I don't know, Judge, whether it did or not. I believe the evidence supports that the leaders of the firewalker team, particularly Mr. Woods that was conducting the training, did talk about, as well as Lieutenant Henry, who did the safety briefing after they watched the video, did talk about unexpected results of felling trees and what to do if a tree takes an unintended fall. There's no evidence that I'm aware of that specifically says these people were trained on what to do if they cut a dead tree. What I would like to point out, though, from the record is in the discussion by the appellant regarding the evidence of the dead tree issue and bulldozing of dead trees is I would point you to the record in the testimony of firefighter Woods, who was the leader doing the training, when he was asked whether or not the S212 course, which of course he had, is there anything, in this on page 63 of the record, was there anything in those courses indicating you're not to cut down dead trees with a power saw? And he says, I don't believe so. I mean, most of all my firewalker experience, and then he goes on to say that in firewalker or in regular firefighter duties, unfortunately, most of the trees that they've encountered that he's ever taken down, this is Woods talking, have been dead or burning.
And that was 4 or 5 trees in his 10 years?
I believe the record is, Judge, and I apologize, I don't have the page citation, that he had done 3 to 4 in training and 3 to 4, an additional 3 to 4 in his career as a firefighter with VOLUSIA.
Is it your contention that if one completes a course, that one is then competent to teach the course? I mean...
No, Your Honor. No, Your Honor.
So I'm not sure that I follow your argument about the fact that Woods had completed this course 10 years earlier and that made him competent to teach this class.
I think based on the length of his experience, Judge, as well as the fact that he had the course, that he was prepared and able to teach the course. In addition, not only did he teach the course, but he stood right there with firefighter Curry and the actual firefighter who was doing the cuts on the tree, who was Slifkin. And Woods was standing right next to them, watching what they were doing. He told them how to cut the trees. This is a task or a responsibility that a firefighter can encounter in his career, whether or not he's on a firewalker team. It doesn't require someone to be on a fire. We don't send just firewalker team members out to handle wildland fires or brush fires or things that may require cutting trees. The testimony of Woods, which is undisputed, is that in his career, most of the trees that he's had to cut or been involved in cutting have been dead trees. And as to the use of a bulldozer, my recollection, I'll rely on the record, was that Greathouse said that was the preferred way to use a bulldozer to drop a dead tree. But if you look at the testimony of Woods on page 65 of the record of his deposition testimony, he says, bulldozers are great, basically, but you don't always have access to a bulldozer when you're fighting a fire, so you use the tools that you have. So I didn't mean to mislead the court and to say that he was certified to train or, had been certified by DOF to give them a certification in this S-212 course. Our position, Judge, is that the email said our people need to be formally trained. It didn't say they need to be formally trained in the S-212 course. It said the S-212 course was a good course and they learned a lot of things from it. But the point of the email, and I quoted it verbatim in my answer brief because I think it's important, because the appellant is relying on that as the sole evidence of this explicit warning that the county had of a hidden danger that was virtually certain to cause injury or death. That is the evidence they have presented to you and presented to the lower court as evidence of the county engaging in an intentional tort as to that element.
Oh, but it almost goes without saying that if you, in a dangerous or untrained manner, cut down a large tree like this, that there's a good chance that somebody's can get hurt. I mean, even without a warning, it almost seems like it's
an open and obvious danger.
It's an open and obvious danger that, this is something that you just don't do cavalierly. And I guess the problem I'm having is, why would they start with an 80-foot tree? If you're teaching somebody to swim, you don't throw them into the deep end of the pool.
Judge, I think the record was that the tree was 40 feet, and again, I'll rely on the record itself. There may have been some dispute as to the actual height of the tree, and I don't believe that's a material fact.
It's 40, I thought I read 80, but even if it's 40 feet, that's a big tree. I mean, why don't you start with something, like a Christmas tree and work on that?
Well, I think we can all second guess what happened or what they did that day and say that they could have done better. But what they did doesn't establish an intentional tort under 440.11.
Tell me how, assuming that the survivors and the heirs can recover the entire $150,000, how is that adequate compensation?
Judge, first of all, I think the record says that they did recover the entire $150,000 that's provided for by the workers' compensation statute. And I think what the law is that, it's an adequate remedy, Judge. Whether or not I don't think that's the issue for the court to determine whether the amount that was received was an adequate remedy, the actual amount, because that's subject to interpretation. We don't know if...
Well, is there a point when people could say it clearly isn't? I mean, what if the legislature reduces it to $10,000?
Reduces the death benefits?
Yeah, say, okay, if an employee of the county dies in the scope of their duties, you get $10,000.
I don't think that I'm sorry.
When does that cease to be adequate, and who decides that?
I think the legislature decides that, Judge, and I don't think that that is necessarily what you're looking at, and we would assert that to some extent, the constitutional arguments in this case were waived by not raising them below, and also were waived by Judge Rouse's decision that there was no evidence, that they did not and could not prove the evidence of an intentional tort.
He never really addressed the constitutional issues at all.
He specifically said he was not addressing the constitutional issues, that he was finding that there was no evidence of an intentional tort, which would get you in to even look at that statute, the statute they are attempting to rely upon. So, correct, he did not rule upon the constitutionality, which means that statute comes to you clothed with a presumption of constitutionality.
And unless we found it to be facially unconstitutional, if we were concerned about the as-applied challenge, that would have to go back.
Yes, Your Honor, that's our position. May I continue?
Yes, ma'am.
Okay. In light of the time here, I want to make sure that I address just a couple of issues as to what the record evidence shows, because your job here today and in reviewing this case is to review the record evidence, determine whether or not the appellant presented any disputed material facts to the trial court, and whether or not the trial court correctly applied the law to the undisputed material facts. It's our position that Judge Rouse, in fact, did correctly apply the law in this case, and I'd like to talk just briefly about Ms. Ford covered the facts fairly well. I think the court is aware of what our position is, the county's position is with regards to what that evidence is. As to the Chapter 440.11, that is called the exclusivity of liability for a reason. Workers' compensation provides immunity to employers for accidents that occur in the course and scope of someone's employment. And over the course of the statute, even before the 2003 amendment, those exceptions of an intentional tort were very narrowly drawn, and that's because they want it to be a hard burden to meet. The legislature wants it, and the courts have decided it needs to be a very high burden because the public policy is that workers' compensation provides a benefit. It provides redress for injuries occurring in the course and scope of someone's work. In exchange, an employer gives up, essentially has a strict liability standard to meet, and that's the purpose of workers' compensation. So it's exceptionally narrow, and in fact, this court, in the case of Woodson versus Ivy, which was a wrongful death case decided under the substantial certainty, the lower burden of proof, this court said that Florida courts interpret the Workers' Comp Act broadly to preserve immunity in the face of sometimes egregious acts by employers, as long as those acts fall short of intentional torts, culpable negligence, or serious criminal misconduct. A review of the cases that were decided under the previous statute as well as the current statute is that the courts have continued to require that exception to be very narrowly drawn. Based on the undisputed facts in this case, Judge Rouse found that the appellant did not and could not reach the level or prove an intentional tort as defined in 440.11. Now, I'm going to talk briefly about the elements of that statute, because there are three elements of that statute that the employee, the appellant in this case, must prove by clear and convincing evidence in order to establish that the county committed an intentional tort. And it's not one or two of the elements, all three have to be, there has to be evidence of all three for the appellant to be able to proceed in this case. The first element says, and I'm going to read it from the statute because I find it, if I don't read it, I may misstate it, that the employer engaged in conduct that it knew, based on explicit warnings specifically identifying a known danger, was virtually certain to cause injury or death to the employee. In this case, as you pointed out, the appellant is relying upon this email from Captain Burnshead as the explicit warning of a known danger that was virtually certain to cause injury or death. Appellant says that the county had this explicit warning that if they did not provide this S212 course, and this is how it's couched in their briefs, that if the county did not provide the S212 course before allowing people to engage in felling trees, that it was virtually certain that someone would be injured or killed. But the evidence doesn't establish that. The evidence shows that prior to this date, there had never been such an accident, and I'm not trying to say that they're relying on the section that says prior accidents as evidence, because that's another portion of the statute that the appellant's not relying upon. But what I'm saying is that that is not sufficient, clear, and convincing evidence to establish that the county was on notice that allowing someone to fell a tree without having had this course would be virtually certain to result in their injury or death. The evidence was that the appellant had knowledge that cutting trees was a dangerous activity. They were trained on that prior to going into the exercise. Appellant also argues in her reply brief that the email also says property damage or injury may be sustained if tree felling is performed by untrained personnel. And I took that right out of her reply brief. That's not exactly what we believe the email shows, but even if you accepted that, may is not sufficient to get to virtually certain to cause injury or death. The appellant also lists a number of acts and omissions in their initial brief, saying that these altogether amount to conduct that is virtually certain to result in injury or death. And I briefed it in my answer brief that we believe that element should be read together, that there's explicit warning of a known specific danger that's virtually certain to cause injury or death, and that there's no evidence in this case that the county was on notice that what would happen on this day would happen if they allowed somebody to, and I need to point out that Mr. Curry was not the one actually cutting the tree. He was not the sawyer. The sawyer was someone named Slifkin. Curry was standing next to Slifkin as the swamper, and as the record shows, when the tree began to fall in the unexpected way, Slifkin stepped around the base of the tree and was not injured, and Curry ran. But I also want to point out that Woods, who was trained in this S212 course, the best evidence you have that this is not an explicit warning of virtual certainty to cause injury or death by not having this course, is that Woods was trained in the course. And he stood right there up until the final cut was being made. And there's no evidence that the cuts were made improperly. There's no evidence in the record. And it still happened. So it wouldn't have mattered if Woods had been the ones actually making the cut. He had the training. the end result would have been the same if the other facts remained the same. That is that Mr. Curry ran down the path that the tree ended up falling on.
But the purpose of the email, you're arguing, is that felling trees is dangerous. We shouldn't be sending our men and women, firewalkers, out into these circumstances with no training, and so train them. And what was going on was a training.
Yes, Your Honor. That's our position, and a little tweak to that is that it's our position that the email doesn't specifically say, it says felling trees is dangerous activity, and if they're dead, it can be even more dangerous, but it doesn't say, therefore, you need to make sure that all of our people have this DOF S212 course before you allow them to train. It says they need to have some training, and that there's a potential liability if we don't train people and something happens. The appellant must show, under the case law, under the statute, that the given danger that's identified will result in every or nearly every instance. Mere knowledge that it may happen, or it's a possibility or even a probability, is not sufficient to reach the level of an intentional tort. And while we don't concede that felling a tree without the specific course will make injury more, without a specific course may make injury more likely, even if this were so, that's not evidence of virtual certainty, which must be met in this case. So the possibility or probability that something is more likely to happen than not is not sufficient evidence to show the virtual certainty. Briefly, I want to point out the second element that the appellant or the plaintiff would have to prove by clear and convincing evidence is that the employee was not aware of the risk because the danger was not apparent. Clearly, the danger was apparent in this case. As Judge Orfinger pointed out, it's an open and obvious danger when you're cutting down trees. So,
well, I think it's an open and obvious if the tree falls on you, but it may not be open and obvious that the risk of having it fall in the wrong place is there if the tree's dead and you've never engaged in this activity before. I mean, I don't know anything about chopping down trees, and I don't know that I would appreciate the difference between a dead tree and a live tree, and I can understand that I could appreciate if a big tree fell on me, that would not be a good thing, but you know, I'm not sure that you get quite the mileage out of that issue that the county may hope for, but that's just my view.
Judge, I would submit that in addition to the, cutting down trees is dangerous, whether you know what you just described, but in addition, we have evidence in the record that they were told in the training that it could take an unintended path, that something unexpected could happen. They were told what to do if something unexpected. That unexpected could certainly include a dead tree taking a fall in the manner in which it did in this case. There's no dispute that this was a tragic accident, and we're not trying to minimize that whatsoever, but in order to pierce the immunity that the employer is entitled to under the law, they have to have more than just an accident.
To what extent, and I don't know if it was argued below or not, but to what extent does the fact that the work of being a firefighter, whether you're running into a brush fire or whether you're running into a burning building, is an inherently dangerous job in and of itself? Does that have any effect on how one would look at whether or not these elements have been proven?
Judge, in the case of, in the List case, which is cited in our brief, that very thing was addressed, and it said, because it's a stringent standard to overcome immunity, first of all, the issue is amenable to summary judgment by this court, but it went on to say that some types of work are so obviously and inherently dangerous that the danger is obvious to anyone, and therefore an employee can't use that to prove that he was unaware or that the danger was concealed, which is the third prong that the appellant is required to prove, that the county deliberately either concealed or misrepresented the danger that the employee was about to engage in for the very purpose of not allowing that employee to make an informed decision about whether to do the work. I believe I'm out of time. And we would ask, Judge, that you affirm the trial court order granting the motion for summary judgment in favor of the county. Thank you.
Thank you, Ms. Jones.
I have so many issues, I don't know where to start, but I'll try to get to all of them. First, I want to reemphasize that the email mentions several times the DOF class specifically, and that Mike Inglet specifically said, "I highly recommend taking the power saws class from DOF." So that was definitely the focus of this conversation.
If that class is the gold standard, does that establish a standard in law? Does the county have to necessarily go to the gold standard, or is there something less than that that might be adequate? I mean, in hindsight, we know this wasn't adequate, but is the county required to go to the gold standard in every training exercise?
Well, I would submit that that's not the gold standard, that that's the minimum standard. And this email refers to needing to make sure that members are formally trained, and that reference to formal training is back to that DOF class. So I would say it's not the gold standard, it's the minimal. Going to this comparison of drill versus training, I would just invite your honors to compare the team training schedule, which is the exhibit to Slifkin's deposition, which has all the classes, including the S212, to the drill schedule, which refers to what's going to be handled on that particular day. That drill schedule refers to the subject matter, which is none of these classes. The drills were not designed for training. The drills were should have been treated as refresher training for those who have already been properly trained. As far as the video is concerned, counsel for the county said that the video that was shown was the DOF video. There's actually testimony on the record. It was asked whether that video was replaced subsequently, and the testimony from, I believe this was Mr. Greathouse, but I'm not certain of that, said, "I don't know if it's been replaced, but we don't do our own chainsaw instruction. We do it with the Department of Forestry. They had different videos from that one in their class." So this video that was shown on this day was not even the DOF video.
And they didn't watch the entire video.
And they didn't watch the entire video. The testimony was that the video itself was 45 minutes to an hour, and they only watched 20 to 30 minutes of it. One person testified back to that.
And was the testimony, as I recall, because part of it dealt with stuff on the West Coast, and therefore it wasn't...
One witness said that was the reason why, yes.
Do we know if Mr. Curry acted consistent with the instruction that he would have received in that 20 to 30-minute video?
We don't know exactly what instruction was in that video, so I can't answer that, Your Honor. What I would say is that Mr. Curry followed the directions, the orders of his superior, Mr. Woods, who led him to believe that it was safe to cut down dead trees. In fact, these trees that were being cut down had been previously marked, all three of them, and all three witnesses conceded that these were dead trees that had been pre-selected. So he was following the direction of his superiors to cut down dead trees, which at least one witness, and that's all we need, is one witness testifying that the DOF says that you should not cut down dead trees. Even if somebody else says it's okay, it's safe, there's a safe way to do it, sometimes we have to do it. This is a summary judgment motion, not a trial, and that's what we need to focus in on, the evidence in the light most favorable to Mr. Curry. The motion for rehearing, Judge Orfinger, you asked about preservation issues, is at pages 134 to 135, and it specifically says that argues that the amendment was unconstitutional both facially and as applied, and then it contains argument to both of those.
And Judge Rouse, as I understand it, didn't rule on the constitutionality, so if we were inclined to rule on that, it would have to go back for further consideration.
The way he addressed that issue was, he said, well, he did not find that this was an intentional tort, and therefore he did not need to get to the constitutionality of it. To be honest, the argument or that logic I didn't quite follow that, so.
He just indicated he wasn't going to get to the sovereign immunity issue.
Exactly. And then on the constitutionality issue, he sort of, I can't honestly explain the reasoning behind that.
All right, why don't you take just a second now and wrap up, because you've exhausted your time.
Sure. Your Honor, I think I'll wrap up on the point that I believe, Judge Orfinger, you mentioned, which was caps. And there's actually the Smith versus Department of Insurance case, which was a 1987 case by the Supreme Court, dealing with caps on non-economic damages in the tort reforms. And they found that it was unconstitutional to put this cap on damages. And they specifically said, along the lines previously mentioned, that if the legislature may constitutionally cap recovery at $450,000, there's no discernible reason why it could not cap the recovery at some other other figure, like $50,000, $1,000, $1, none of these would be, totally abolishing a right, but it would still be unconstitutional. And that's what we would submit to your honors that is the case here. This statute has been written in a way that makes it virtually impossible to meet it. And so if your honors were to determine that the facts here do not meet the statute, even on a minimal level and sufficient to pass summary judgment, we would submit that the way the legislature has now crafted the law has made it virtually impossible and effectively eliminated a cause of action that did exist at the Declaration of Rights passing.
Thank you so much. Thank you both. Well-argued case.